Thank you, Susan, and thank you to the Justice for Journalists Foundation and the Foreign Policy Center in Ibari, of course, for hosting this really useful and timely conference. It's really great to see so much attention to and support for those fighting SLAPP in all of its forms. So I think Carole needs no further introduction, but I will say award-winning journalist Carole Cadwalladr, we're really proud at RSF that one of the awards that she does have on her CV is ours. She won the RSF Press Freedom Prize in 2018, which I know she's got a collection of other accolades sort of on her shelf, but we're really proud about that. So we consider Carole among those internationally who we recognize each year for their fight for press freedom. Carole, I think everybody has this vision of you as this, courageous journalist who's battled the SLAPP case, but it might be worth just going back to the basis of that case as a reminder, maybe for those who haven't gotten into the details for some time, or, as an explainer a bit for those who aren't familiar with it. It all started with a TED Talk.
It didn't start with a TED Talk, I think, actually. I mean, I started writing about Arron Banks and Leave.EU in November 2017 for the Observer newspaper. I sort of fell down this rabbit hole into this world of fake news and started reporting on this strange company I came across called Cambridge Analytica. And so I think the thing that sort of gets lost in this is that Arron Banks's case against me is intimately tied up in my reporting on Cambridge Analytica and Facebook. And indeed, none of that would have happened if I hadn't met Arron Banks's business partner, Andy Wigmore, and he'd started telling me about their work with Cambridge Analytica. So it really started, I really consider that, I started reporting on them in the first sort of big piece which focused on that was in February 2017. And, that article was set in train a certain number of investigations, one of which was into Leave.EU and its potential breaking of electoral laws and its potential breaking of data laws, both of which were then found. So it's like the bedrock of this comes from much earlier. It's a body of work that I started doing into the Leave.EU campaign, which Arron Banks headed, that then led to the sort of our big revelations in the Observer and New York Times in 2018 with Cambridge Analytica and Facebook. And then in the summer of that year, I then reported with a fellow journalist, Peter Jukes, on this stash of emails that we'd got between Arron Banks, the biggest funder of the Brexit campaign, and officials at the Russian embassy in London, and their communication and contact and business deals in the run-up to the Brexit vote. So that was all the background. And then what happened is in the spring of 2019, I was asked to do a talk at TED about the Cambridge Analytica investigation. And that talk, it wasn't, you don't break stories in a TED talk. This is not where you reveal exclusive new evidence. This is where you sum up, I was trying to tell the story of the investigation so far. And in the course of that, I mentioned 23 words about that bit of the story, Arron Banks and his relationship with the Russian government. And it was at that moment that, actually, it wasn't even sorry, can I just add one tiny little thing? Then what happened is I tweeted about a Netflix documentary that was about to come out called The Great Hack. And it was tweeting about that and mentioning Arron Banks. That was the moment that he went to sue me. And I think that in the context of this being a SLAPP, I think that's actually really important, because all of my work to that date had been in the context of it being published in the Observer. And it was that moment when I was doing something, as I sort of say, storytelling around this investigation by myself at the TED conference, which was when he launched this lawsuit.
And
that was a really long answer, Rebecca.
No, not at all. Not at all. It's a really complicated case, actually. And having sat through the legal proceedings, keeping this to 45 minutes might be a challenge. But, there's been a lot of conversation around whether this was a slap. And of course, Arron Banks always denied it and had his feelings hurt. It seems by the fact that all of these pesky free expression organizations considered it a slap. We absolutely do still consider it a slap. But you mentioned, you said these things at TED. I think something that came up in your trial, which also to me underscores that it is a slap, is he didn't sue TED. It was edited. It was published. It's still continuously being published by TED.
He never ever wrote to TED.
Never.
There was never a single letter of complaint to TED. He never asked to have that talk edited, amended, taken down. There was absolutely zero attempt to go after them. The same allegations, there's almost identically the same words as the judge explicitly said in the judgment were published in the Observer a year earlier. Those same words were published by them. He never went after, he never wrote, he never asked for correction, he never denied it. So it's and then, as I sort of said, it was very much picking me out as an individual. I mean, actually, I want to say one thing as well, which is that the involvement of I'm so pleased to be here today, and I'm so delighted for the progress that you're making with this anti-SLAPP coalition, because it was, for me, not having organisational or institutional support, and living with this strain and jeopardy over so much time, having the support of the anti-SLAPP coalition putting out statements and saying this is a slap, we stand in solidarity, we stand in support, was really, really significant and helpful, and I'm extremely grateful for it. And of the things which made a difference for me, that was sort of, during the actual trial, was one of the most important.
Well, maybe we can touch on the ruling itself and then get back a bit into that solidarity question, because I think it's an important one. And it's a reason that journalists are isolated in the way that you were. This really ended up being a key test of the public interest defence here in the UK. Maybe you could tell us a bit about the judgment and sort of what it means for journalism going forward.
Yes, I very much, when I just thought the case was preposterous when he wrote the first letter, because he was I had claimed that Arron Banks had lied about his relationship with the Russian government. And that's the same claim that we'd published in the Observer. And it was so easy to prove. That was the thing about it. It was like, I was really unworried about it initially, because I was like, well, we've got the documents. It's like, this is like, slam dunk. It's really easy. And then the thing which completely threw me was going to this meaning hearing. So I don't know, for this, there's this sort of complicated process. I mean, libel is a really complicated law. That's the thing that I learnt. Gavin Miller, my barrister, kept on saying, he kept on, he was always making that point of like, it's really unobvious, it's really technical. And we had this pre-hearing where the judge decided, had to look at the talk and the tweets and decide upon the meaning of them. And I trotted into court very confidently. It seemed to me absolutely clear what the meaning was, because it was stated there in the words. I'd said he'd lied about his covert relationship with the Russian government. What was so difficult about that? And the judge had this, it was this baffling hearing, and right at the end of it, it seemed that the judge sort of plucked this meaning out of thin air, which is that he said that it meant that Arron Banks had accepted money from a foreign government in contravention of the laws as such. Sorry, I haven't got the precise wording. So he was saying, instead of the allegation being that I said he lied about his covert relationship with the Russian government, which I could prove, I now had to prove that he accepted money from a foreign government, and that was illegal. And so at that point, it was, I could no longer run a truth defense because a judge sitting in a high court in London had decided the meaning of those words for all people of all time across the world forever. At that point, it's that, I took this massive battering. It was this Cadwalladr withdraws her truth defence. Her journalism's in ruins. We must strip her of her Orwell award. I kind of had this torrent of abuse from the right-wing press. But, legally, it didn't matter, supposedly, because we now have this defence in British law of public interest. As long as I could justify the journalism behind what I'd said and why I'd said it, and could show that to the judge, then I would have to be found. The case would be denied. But the sort of devastating thing to me was, and it really was, the meaning hearing was when the case got incredibly difficult for me. And Tamsin Allen, who was my solicitor at the time until she was conflicted out, which was another sort of devastating blow, she said to me, she said, it is the thing with a public interest defence is that it all rests upon you. It's all about your journalism now. It's all going to be about trying to destroy your reputation. And she said, it's going to be incredibly difficult because this doesn't happen. In libel, it's normally the organisation is up there. There's a stream of editors who come up and justify this stuff. And the journalist comes in and says their bit, but they're only one part of it. Whereas this is going to rest entirely upon you. And it's going to, and I think that was knowing that the whole thrust of the case was about destroying me, breaking me down, smearing me as a journalist, smearing my processes. And to do that, they were going to have access to all of my documents. Everything from a kind of 5-year investigation I had to hand over for these forensic searches. And during that whole period, I also lost my solicitor because she had written an update for my crowdfunding page that Banks is claimed had all defamed him again. And so because he claimed it had defamed him again, Tamsin was conflicted out of representing me because she'd written it. So I was in the spring of 2000, last year, essentially, I'd had this meaning hearing, which saddled me with these words I'd never said. There was 30 plus articles smearing me in the right-wing media, Russian state-sponsored media, American far-right media. My name was trending across Twitter for about 5 days. The Orwell Award, the head of the Orwell Awards rang me up and said, "Don't worry, we're not taking this." They were sort of saying strip her of her awards. Then, he claimed I defamed him again with the crowdfunding update. Then I lost my solicitor, who had been a real sort of source of help and comfort, and I had to find a new one, and on reduced fees. So I was very lucky to get taken on by Keith Mathiasen at RPC. Then I had to hand over all of my laptop and phone and passwords to all of my accounts for these forensic searches, and I just couldn't cope. I really couldn't cope. And I think the whole thing about it is because of the ways that I'd been repeatedly sort of attacked in the right-wing media and on social, in this very sort of every step of the lawsuit was used to fuel further attacks. I knew that anything I handed over would be used and weaponized against me. So this entire investigation, which had resulted in, really consequential fines, a $5 billion fine against Facebook, all of these regulatory penalties, the fact that they'd been found to have broken the law, it was being that was being turned back on me as an individual. and and I was just having to deal with a loan. The law is it's just so technical, and I didn't understand the legal process and sort of like what was coming next. And so I found that whole period completely debilitating.
And you say that you couldn't cope, but from where I'm sitting, you absolutely did. I mean, and we can get a bit more into the abuse sort of around this too, but this is really highlighting why so many journalists don't fight back or aren't able to fight back. Not just journalists, individuals who find themselves targeted in this way. But you did. You crowdfunded and you took this to court. Trials like this do not
I know, but
happen.
I kind of like, it was never, we were trying to settle. It wasn't that I was like, no, I'm going to court, whatever. This is like, fight my trusty sword of truth. I was just trapped. This is where the kind of Kafkaesque thing is, that you're just trapped inside this legal machinery and there is no way out. And that was the thing which I just found so debilitating, because there was literally nothing I could do. And I just became paralyzed. I think my solicitors would say, I was just really late. We were really delayed handing over my stuff and doing the forensic searches because as I sort of said, is that this sort of paralysis sort of slightly kicked in. And I think this thing about finding it so overwhelming, it was like it really affected my cognitive faculties. I couldn't think very clearly around some of this stuff. So it was all, I did fight, and to say on the crowdfunding thing, I mean, the generosity of people, I mean, that was so kind of overwhelming that, it really felt that people could see what was happening, that this was bullying, it was intimidation, it was harassment. It seemed very clear, I think, to the public. And so having that support was amazing. And there is no way that I could have, continued without it. And I'm really, really super aware of other journalists and other individuals who don't have that recourse. It was such a, singular situation that I was able to. I think through this period is that it's I just sort of thought it's not just the lawsuit that is the thing, it's the other harassment that goes alongside it, and that is which had, from Banks, there had been a catalogue right from the beginning, physical sort of threats of violence and relentless misogyny. That was part of it. And I really did feel is that this news organizations, in the sense that like one of my biggest concerns is that news organizations just don't really understand. There's this sort of new landscape of threats for journalists, and they don't appear to understand it. And I think it is a threat to journalist safety. I really do. And so that's where I've sort of, was still agitating and for greater awareness and greater support and protection for other people, because we know that the people who are most often targeted online, for example, it's women, and it's women of colour in particular who get the most, abuse and harassment this way. And I just sort of thought, if there's, I'm as old and grizzled as I am, and I'm finding this so difficult to cope with. If I was in my 20s and sort of facing this, I would really worry about that person's ability to cope.
But you've spoken out so courageously about it. At one point, there was an in-depth study on the misogynistic nature of the online abuse against you, which I thought was really enlightening. I believe that was authored by Julie Pizzetti and published with UNESCO, who also looked at a few other women journalists facing legal trouble, such as Maria Ressa.
And that was so helpful to me to have that sort of analysed and quantified, to have a UNESCO report I could point to. And, Julie's research shows that the person who had precipitated some of the worst misogynistic abuse against me was Arron Banks. I mean, he was named in it. He was very much a sort of central node of that network.
Absolutely. And the bullying was not just online. Of course, it cut through even in the hearing itself. I remember the cross-examination was particularly brutal. Every aspect of this was sort of brought, to a head. And he was sitting there almost with I don't want to quite use the word disdain. It was almost as if he was enjoying aspects of it himself, and then the cross-examination of you was really intended to unnerve you, to sort of almost back you into their narrative of things. How did you cope with that?
I mean, it was you were there. It was extraordinary. I can't think of any other place in modern life where relentless misogynistic bullying can take place in public in plain sight with somebody who has no choice but to be there, and that's allowed. I mean, it really shocked friends and people who came and sat in the trial. I had several women come up to me and say, I'm finding this really difficult. This reminds me of, this situation in my marriage. That was what one of them said. Another one was who works in the civil service. She was so shocked at the idea that you can kind of get away with this in a workplace, this kind of behaviour. And, it did reach a pinnacle in the case when, there was this sort of attempted sexual shaming, is how I describe it. And at that point, my solicitor, Keith Mathiasen, who has been a solicitor who's done all of the big libel trials for years. And the thing about libel is it's apparently it has the most sort of brutal cross-examinations of any kind of trial, because it is all about breaking down the witness. And Keith has done all of the big trials forever. And he came out and he said, that is the most aggressive cross-examination I have ever seen. And he said, there is no doubt that it crossed a line. And he said, both him and Gavin said, the judge will have to understand that this is on the directions of the client. You could not engage in that kind of behaviour in court unless it was on the explicit direction of the client. And the judge will have to understand that this is misogynist, it is the misogynistic bullying that you've been talking about. So that is, but after the trial, that was, I think, this I was really, I was so shocked, but I was also just really angry about it, because this was the High Court. This is the British state. This is the machinery of our law and courts, which was being deployed to, as I sort of say, abuse and bully a journalist. And it just felt really, really wrong.
It absolutely did. And at the same time as that, it also felt that there was a fundamental misunderstanding about journalistic processes. I remember that was a big part of the question.
It's extraordinary. Yeah. There was this one. Are you telling me, Miss Cadwalladr, that it's normal journalistic practice to Google things? It kept on going. And it was so hard because you doubted yourself. And, when he asked me that question, I was like, is it? And I was like, yes. And, and we had that all the way along. And he kept, one of the points they kept on saying, are you telling me, Miss Cadwalladr, that you cannot take sole responsibility for those words which were published in the newspaper under your name? And I was like, no. That's the whole thing. Journalism is a team sport. It's editors and it's sub-editors. We don't write the headlines. We have no control over the published copy. You cannot say at 2 years distance, how that came into being. And that is why, the whole approach of this, of a single journalist going up to defend these words, is ridiculous. That is not how the process works. And having, lawyers in a London courtroom, ruling on this world they know nothing about, and as I say, determining meaning for all people of all time. The whole thing was just absolutely absurd. Sorry, that came out.
No, not at all. But that was repeated several times, was that journalism is a team sport. But I can imagine sitting there, and not just in the courtroom, but throughout this whole process, it probably didn't feel much like a team sport in the way that you were targeted.
No, and it was, and again, it really didn't. And it was, it was, it was, oh, how do I say this? A team, it was, I can't take credit for single-handedly for the journalism I have done. I did that with the help and support of colleagues, with lawyers at the newspaper, with editors. It is quite right that the Guardian and the Observer takes credit for the Cambridge Analytica Facebook investigation. We couldn't have done it without, that team. And, all of the things which came about because of that investigation, because of this journalism, the investigations and fines into the breaking of electoral law, the breaking of data law, these record-breaking fines in the US, these congressional inquiries, these new laws which have come out of it, that is all a result of our journalism at the Observer and the Guardian. And equally, I was not responsible for it shouldn't have rested upon me being singled out and carrying the can for all of it. And, that is not right. It's not fair. It's not ethical. It's not, protective of just like fundamental kind of workers' rights. This was something which came, this whole experience was a result of doing my job. I mean, I was doing my job for the newspaper, and sorry, I'm really not being very articulate. You take over, Rebecca.
Well, maybe I'll put it to you a bit more directly. Do you feel that the Guardian and the Observer supported you sufficiently?
So, to be completely clear about this, I have wonderful colleagues who showed great kindness and personal support, which I'm hugely hugely grateful for. But at an organisational, institutional level, the Guardian and Observer fundamentally let me down. And I haven't spoken about it in public before because no good would have come of it. Because the whole intention of a SLAPP case is to separate the journalist from the organisation, which it did really successfully. And so, I was grateful for whatever support I could get. But no, I think, there is an institutional failure there because the judgment is really, really clear about it. The judgment said that the Observer had previously published the same words. And she was also really clear about the process of how the TED Talk came about. And it wasn't just that TED's editors and legal team all reviewed it, but also 4 editors from the Observer reviewed it and gave feedback and fed into the different drafts. And the head of corporate communications at The Guardian asked me to send it to him also for review. Like that, the idea that the organisation had nothing to do with that TED Talk is a fiction.
And what would have happened if you had lost?
And so, in the week before trial was incredibly fraught because there were still these kind of settlement negotiations going on. Banks was texting me directly. And, what I really needed to be doing was focusing and reading the files and making sure I'd reviewed the evidence and was prepared to go into court. And instead, I was in total, completely sort of, flustered meltdown because I just didn't know what to do. Because I was in the situation whereby if I went to court, my odds were high according to my legal team, but that 75%, I think, was being quoted. But that's still a 1 in 4 chance of losing. And if I lost, I was £500,000 short. So I had a 1 in 4 chance of going into court and coming out needing to find another £500,000. And I wouldn't be able to crowdfund then because I'd had judgment going against me saying X, Y, Z, she was an irresponsible journalist, or my other alternative was to settle and expunge these words from the record forever, take down the TED Talk, presumably. And I would still need to find an extra £250,000 because I'd have to pay out my side's lawyers who'd done it on reduced fees. So it was really between a rock and a hard place, and I really didn't know the right thing to do. And we still, at the doors of the courts, we were late starting on the first day because the judge granted us extra time to try and reach a settlement even then. So it was just incredibly fraught, and it was, and I felt really underprepared in that way when I went into the witness box because, as I sort of said, instead of having, and I think maybe that's not coincidental either.
I think it's really important that we have an honest conversation about this in the media industry, because it's not just the people who file such lawsuits, but sort of the isolation that you can feel. There could be perhaps a chilling effect on others who have freelance arrangements with their own publications, that they know now, if they end up in the same situation as you, that they may not have the support of their own publication.
Yeah, I mean, the chilling effect is absolutely there. I mean, so one of the things Gavin Miller, my barrister, says why you can see this is so clearly a SLAPP case is because there was an amazing amount of journalism done into Arron Banks before my lawsuit, not just by us at The Guardian and Observer, but there was brilliant investigations by the FT and Open Democracy and New Yorker and Channel 4 and the BBC. And then it just stopped dead. So that chilling effect absolutely worked. The chilling effect for freelancers is, I think that's not just freelancers, actually. I mean, this whole thing about how we are encouraged as journalists to go out and talk about our work, going on radio or giving talks at events, going out and participating in public and sort of advocating for our journalism, that is part of the modern process. And it's very, it's a different thing talking. You can, and I got really paranoid about saying the wrong thing and after this. But I think it's something that actually all journalists should be aware of. And yes, for freelancers, I mean, news organisations wouldn't exist without freelancers. They're the backbone of many publications, and I think this, to be honest with you, I mean, one of the key things about it is I wasn't really a freelancer. I worked full time for the organisation for 14 years by that point. I'd been a full-time feature writer over that entire, period. And so, I was a freelancer in name, really. But when push came to shove, is that the argument was that I wasn't on the insurance because of that. And that was the sort of distinction made. And I think one of the sort of things subsequently, talking to other editors at other organisations and other media lawyers, is that it's not just that you should also protect the freelancers and support them legally and through other means, but it's especially the freelancers you've got to support and protect, because they're the weakest link. And if they go down, then you're going to go down too, because it's your journalism. If you can't, and this is this thing is that, organisations need to defend their journalism, which means they need to defend the journalists. So the message for any news organisation out there, and the Guardian's US counsel actually told me this. He said, I always tell news organisations, you must protect the journalists and the freelancers, because otherwise it goes up the chain. So there's self-interest in this too as well. I think that's one of the really key things to remember for news organisations.
Absolutely. I think we can take one or two quick questions from the floor. I'll start with one online, which is from Ewan Grant, who asks, are there any examples you have seen of increasing or decreasing self-censorship since the Banks action? And do you see things getting any better?
Does that with regard? I mean, as I say, with regards to Banks, the investigation stopped dead. And one of the amazing things about my trial was that this was 1 month before Russia invaded Ukraine, that the main funder of the Brexit campaign stood in the witness box and answered questions about his relationship with the Russian government. And new evidence was put on the record around that. And not a single news organisation covered it in Britain. The only one who did, who sent a reporter, was The Guardian. And I do find that sort of amazing. That and I think looking back, I wonder whether there's any regret around that.
Absolutely. Question here. There may be a mic coming.
Hi, really quickly, I just wanted to say thank you for your incredible reporting on the Cambridge Analytica case. It was so important, and also I'm so sorry to hear about everything you went through. We heard yesterday from David Davis that journalists are creative people and their mind is their asset, and that is what is hurt by cases like this, and I feel like you exemplify that in such a moving way. So I wanted to ask you, from your personal experience, is this model anti-SLAPP law the answer in cases like this? Because it seems to be an example of such a multifaceted attack on the safety of journalists. Do we need to look at it from that perspective? Look at the online and offline attacks? Do we need to consider how to protect particularly women journalists and women of colour? What else would you have needed when you went through this case?
It's such a, I mean, the fact that this coalition has come together and has done so much in such a short space of time is amazing. And it's that thing of having recourse, like I said, that thing about the machinery of the law of the British state being part of this, addressing that first and foremost, I think is a really brilliant start. The online stuff it's more difficult to find solutions to, but I do think it's one of the other things about this question, is it a SLAPP, isn't it a SLAPP? I mean, the thing I wrote in my complaint to the Solicitors Regulatory Authority in the sort of the latest, because they'd asked for more evidence, is that a SLAPP is a strategic lawsuit against public participation. And I haven't written an article I think I've written one this year, and I took myself off Twitter for something like the last 6 months. I mean, my public participation has been, what's the word? I mean, it's worked. It has worked. This was a lawsuit against public participation, and it was successful in that terms. And, I hope that's not going to be the case for the next coming years. And, sorry, I'm drifting again. You're going to have to take over again, Rebecca.
Well, let's see if anybody else has a question. Nick, and then I'll go to the back. And also I'm looking to the side to see if we can get away with a few extra minutes, perhaps. Okay.
Thanks, Carole, and thank you. I know it's obviously having to recount it can't be easy, but one of the things and when you were talking so movingly and, to be fair, alarmingly about the barristers' cross-examination and the judges seemingly comfort us to letting that sort of go on. We've heard about the SRA yesterday. We were talking about the relative inaction from the Bar Council and from the barrister side, and also the need for increasing training for judges as well. How do you see what needs to change in that side? Because at SRA, there is progress, there is movement, and I think, it's, not insignificant, but, we'll see about how effective it is, but there's not been the same thing in terms of barristers and judges. What needs to change from your opinion on that side?
It's a really interesting question. I mean, the one of the sort of things about me was that when I came out of court, I was released from my oath, I tweeted, I think I did a Twitter thread that night, which I think really discombobulated them, actually, because I said, this isn't, the British, our legal system is adversarial. That's its nature. And that's the idea that through that you get to the truth. But adversarial and abusive are two different things. And, there was absolutely no doubt in my mind, and pretty much everybody else who watched it, that it was abusive. It was abusive. And I think that, as a society, We don't like to see racist bullying in public life. We don't like to see misogynistic bullying. We hope that we've moved past that in the workplace and in public life. And I would really hope that the Bar Council has a long, hard look at itself and reviews that and asks whether that was appropriate. And I on the 2 days after the trial, I wrote another Twitter thread, and the thing I woke up with was this. As I sort of said, this thing, it wasn't just this. What happened in court was an extension of what had happened previously. And the fact that the sort of misogynistic, violent, threatening bullying, which had happened online, was then replicated within the courtroom. For me, and that, as I sort of said, this happened in totally plain sight, in the public sphere, wasn't reported on, and I just said. And it just came out of me, which was that I have been through a trauma, and I was traumatized by that courtroom experience, and because of sort of everything which had happened before it, and very much I think that, as I've said, also that sort of lack of protection, essentially, from the organizations, the institutions that you hope are there to protect you. Instead, I felt exposed by it, and the intention was to destroy me, and I knew that was the intention behind it. And for 6 months, it was very much I lived with the expectation that it probably would destroy me. So yes, it was kind of a lot to go through.
I think there was a question back here.
Hello. Can I also just join everyone in thanking you for your bravery and for your recounting your story here? I actually had a similar point to the gentleman in the front about the barrister's profession and the cross-examination. But just one comment then, if I may, which is that if you look at the model anti-SLAPP law, and you juxtapose that with the judge's finding here that, albeit that you succeeded, this wasn't a slap. I just hope that the definition is sufficiently broad and flexible. I think it is. But I hope that we get to that situation where the judge in a preliminary hearing would have found this to have been an abusive litigation, and therefore the reverse onus would have meant you wouldn't have to go through the cross-examination, the intrusive discovery, etc. So just a comment.
Yeah, but I'll respond to that, because the whole thing about it is because there's no definition of SLAPP in UK law, and that was never part of my evidence. No, and that was one of the things afterwards I felt most upset about, in a way, is because that this years of what I considered abusive behaviour, of which this was an extension, was not in the evidence. It never formed part of the case, because my lawyers said to me, that's not what this case is about. You're just here to defend yourself. You're the defendant. I'm not there to make accusations. That was not, that's never part of it. And so although some of it came up in my evidence in court, there was nothing for the judge to refer to. There was nothing she could analyse and make her view on. And I think, the point about her saying this is not a SLAPP was in some sense defensive of the judgment, that she looked at was the facts that she was presented with and made that determination that that this was not defamatory, and did that with this incredible the detail that she brought to the evidence in the judgment. It was amazing. And I didn't go into it with the intention of that we need to have this on the historic record in a High Court judgment. But now I feel very proud, actually, of the fact that instead of wiping the record clean, which was what Banks wanted, instead this amazing analysis and these determination of the facts is contained within that High Court judgment. And, that is there now for the historic record.
I think it's important to note that part of the judgment, and that was the part that we actually disagreed with. Of course, we welcomed the overall ruling, but for Reporters Without Borders, this case still is a SLAPP, even if this court did not find it as such. And I think there are other organizations in this room who would still agree with that assessment. We'll take one final question here in the back, and I think we're out of time after that.
Thanks very much, Carole. Thanks again for telling it today and just being so forthright and open about what you experienced. It does seem as if we need to think about sort of much better protection for individuals, for journalists. Somebody yesterday mentioned that in Sweden you can't sue individual journalists, that there is protection there, that the organizations have to step in. And I think even in this case, when, perhaps they were picking up on something that was said at a TED Talk or a tweet, as you say, the corporate body of evidence came from your work through a journalist working for The Guardian and The Observer. Is there something you think more that should be done that basically means that that sort of context has to be taken into account and that individuals should not be subject to this, from day one?
Thank you, Jim, for the question. Yeah, I think, it's just like, I hadn't thought about it before, but I think what would be really amazing is a code of conduct from British news organisations. Can we not have editors signing up to actually, talking about the commitment? I mean, as freelancers, as employees, as journalists, you're always being told about what the organisation expects from you and your behaviour. What about the behaviour we should expect from news organisations also? And I think in terms of a sort of, and the reason I say that is because I think it would deflect as well. It would make solicitors and lawyers and people thinking of bringing these suits think twice, because you're sort of saying, if you come after one of our journalists, you're going to take on the weight of the media establishment. And I think that's where the sort of solidarity of would, as I say, deter, I would hope, people from taking these kinds of suits. And yeah, so maybe it's actually a sort of industry-wide measure that could come from, rather than a legal mechanism.
And Carole, just in closing, what's next? I guess both for the case and for you.
Well, watch this space. I've got some things I'm cooking up, basically. But I think I've really, as I sort of said, is that I have removed myself from the public eye, and that has not been undeliberate. Is that actually I've needed to step back and to not have that public scrutiny. The whole thing with this case and the way that I was targeted is it made me into this, I call myself a culture war hate figure. It made me into a punching bag. It became acceptable to go after me and to attack me and to, use sort of sexist and derogatory language about me. And I've had enough of that for the time being. And so I've quite enjoyed just doing my things in the background. And that's not going to last forever. I do want to do, do other stuff. But yeah, that's. So yeah, sorry.
So more public participation.
More public participation may be coming at some point. Yeah.
Well, we look forward to it, and of course, you've got the support of, I think, everybody in this room, the audience online, and actually civil society and everybody who cares about free expression. So thank you for fighting this fight for all of us.
Thank you so much for having me, and thank you everybody. I know so many people in this room have contributed towards getting this law changed, and yes, so from somebody who's felt. I mean, actually, a friend of mine sort of said. When I was telling them about what this was happening and what the coalition is doing, and she said, "Oh, you really are? You're going to be like Ruth Ellis, the last woman hanged in Britain." So I hope so. I hope I'm the last journalist to go through a trial like that. I really do.
We hope so too. Well, thank you, Carole, and thank you again to the organisers.